are Group 7, and today we're talking about the topic is intention. Yes, and our case study is between the Rose and Friend Company versus GR, Crompton, and Pros Company. So first of all, I will give introduction about intention. So intention in the contract refers to the determination of the parties that to perform and act in a particular manner, and is a state of mind that all parties have to enter in their contractual obligations. That means like intention is abstract. It's not like easy to see or can understand like another factor, example formation or capacity. Therefore, when we sign any contract, we need to know what are we doing, what are we signing, and then what is our responsibility in this contract. So in the commercial agreement, if there is no intention to create legal relations, the contract would not be enforceable, legal, and binding. Yeah. So next one, I will talk about presumption in the intention. So there are main presumptions when we talk about intention, which are social and domestic agreement and commercial or business agreement. So social agreement, we can easily understand it's like in general life when we do in the promise between friends, between husband and wife. So this agreement normally not intend to be legally enforceable. So I take example like this. When you and your friends make a promise that your friend told you that I will have you anytime, just call me, right? And you think that he promised you, and then when the thing happened, you call him, and he just say, "Oh, I'm sorry, I'm busy." So it's very easy to understand this kind of politeness. He just promised you in the conversation, but he didn't he will not intend to make this promise. Or between husband and wife, or like a relationship, like couple, when the man promised to the woman that he would do anything to please her, but in real life it's not like that. Then the woman may sanctify and then say that, blame the man that, oh, you promised me like that and you did not do it. But this is not intention when he makes the promise. So the next one is the commercial or business agreement. This one is the one we need to concentrate about. So when we do the contract, right, it belongs to the business agreement. So in this area, the court will presume that it was intended to be legal enforceable. It means if you break the contract and you don't have intention, you may not be legal enforceable. But if you have intention, then you have to have responsibility with that, and then they may sue you, and then you have to pay for the damage. So next one, my friends will talk about the case study. Yes. And
Good afternoon, everyone. I'm going to talk about the fact and legal issues of Rose and Franco at J.R. Crompton. So that is the three companies. Rose and Franco RFC is appointed as a sole agent for the sales in the United States and Canada for the carbonizing paper tissue.
Oh, this is all clean, is it? No, that's all. Ah.
So, Rose and Franco RFC is appointed as the sole agent for sales in the United States and Canada of carbonizing product supplied by RFC, which is J.R. Crompton. And in 1913, there's a written agreement between the was entered into the three parties, which is RFC, J.R. Crompton, and Brothers. So that J.R. Crompton and another company is of manufacturing carbonizing product is Brothers began supplying Rose and Franco. The agreement had a 3-year term, subject to termination in given of 6 months of notice. However, the relationship between the three parties broke down as J.R. Crompton and Brothers refused to supply the product. Some of the others to the plaintiff is Rose and Franco. So the Rose and Franco sued those two companies in the enforcement of the agreement. However, in the agreement included a clause which is called honorable pledge clause, so that each of the three companies agreed to come to collaborate to each other on their friendly relationship and mutual loyalty and friendly cooperation. So the legal questions here is, did a legally binding contract exist between those three companies, that is RFC, JRC, and Britons, which is called Brothers? So did a legally binding contract really exist between them, and whether JRC and Brothers failure in giving of 6 month notice to the Rose and Franco, and whether they are really breached the contract. Next one, please. In the relevant law, intention of contract law is that not every agreement is the contract. Even though the parties in the agreement must intend that contract is legally enforceable, it is possible for that presumption to be rebutted by evidence. That is, the Britain agreement may contain an honorable pledge clause. So that will be resumed that the agreement is in binding honor instead of legally enforceable. So the next one, my friend Victor will talk about the applications and the conclusion of the case. Thank you.
Hello everyone, my name is Victor, and to continue my friend, I will introduce you guys about the application of this case. So you can see at the slide that the first two cases will be cited in the judgment about this case. So according to the laws of Pakistan, there is no legal enforced contract, and the document is not form the legal binding contract. But the activity of order and response between the party maybe build the end for contract of sale. So the first question in this case is whether the document signed by the defendant on July 11, 1913 and the counterpart signed by the plaintiff signed August 12, 1913 has constitute a legal contract or not. So to understand that, we have to create a contract, there must be a common intention of the party to enter into a legal obligation, mutually communicated expressly and impliedly. So in this case, the plaintiff had claimed the alternative statement that against the defendant. They say that before 1913, they have 4 years doing business with this defendant, and on the term of binding agreement terminal on notice, and that if the agreement made in August 1913 is not result in contract relation, the contract in existence at that day had never been terminated, and they sue for their breach. So the court explained that the argument that clause restricting the legal enforceability of a contract applies solely when the document is otherwise unquestionable of legal force. So in this case, the Rose Company had claimed that they have been doing business with the GR Frenton for many years, which in the legal contract say that if they want to stop the contract, they have to notify for them in 6 months. But the moment that they sign a new contract in 1913, which say that the new contract have been signed in 1913 is not a legal. It's not a legal contract, so. So next one, I go to the conclusion. In the conclusion, the JR Compton and brother did not have to give 6 months notice of termination, and the termination of the agreement without notice were valid and effective due to the fact that the lack of enforceability of an express legal agreement under an agency agreement does not preclude the legal transaction. So the order constitutes mutual offer and the acceptance or anything that's with each transaction having additional legal significance. So the last one is the overview of this case and what my friend will introduce about that.
Good afternoon, everybody. My name is John. I will talk about the overview about our topic presentation. Intention in very contract law is very important. Contracting party must have an obvious mind to enter serious contract. The contract would not be enforceable, legal, and binding if there is no intention to create legal relation. When there is no intention to create a legal relationship, the two parties cannot sue each other. The contract may become a mere promise without intention to create a legal relation. The contract lacks a binding effect if there is no intention of legal relations. So thank you for your listening.